Luckily, we have a provision under the IT Act and the rules which make adequate provision for punishing people who are resorting to deep fakes. But the penal law, while this in my view would also be a penal offense, the penal offense is being addressed by virtue of the IT Act being capable of roping in such a mischief. So some of these new developments that may happen would need to be incorporated into our law from time to time. For instance, madam, I also find that while we have taken care to bring in snatching of mobile phones or movables as an offense, we would still have to go back to the IT Act for the purpose of a data theft. Someone may not steal the mobile, but someone may actually be stealing the entire data from the mobile. Now, this may possibly come within the meaning of theft, which is very broadly defined under the old IPC and also under the new enactment. But there is no separate offense which deals with data theft. Now, as we go forward, there may be further developments that may happen where the law may have to be amended for the purpose of incorporating this. So, ma'am, I have a suggestion for the government. In the insolvency regime, we have a permanent committee which is called the Insolvency Law Committee. The law committee constantly looks at the developments in the field, it looks at development in the courts, and it constantly keeps making recommendations to the government that if a particular provision is introduced or if a particular explanation is added, it may clarify the position, and the government has been making these changes in the insolvency and bankruptcy code from time to time. Now that, madam, deals with a very simple law in the relative context of the criminal administrative laws that we are looking at, and in that narrow space, that law has been very throbbing and has been alert to the needs of the society because of the Insolvency Law Committee being a permanent body that continues to make recommendations. So the recommendation, ma'am, I have for the Honorable Home Ministry is, the Honorable Home Ministry may consider, the government may consider having a permanent committee which could be headed by people who are experts in these areas, who would also get a feedback from the stakeholders, from the lawyers, from the judges, from the litigants, and then see how some courts are interpreting some of these provisions, because some of the interpretations may go contrary to the spirit with which the law has been made. So a small addition, small alteration, a small explanation may make a huge difference. So, madam, this is one of my suggestions for the government, because this would make the law nimble, agile, and it will be very quick to react to whatever is needed of the society. Madam, the next point that I wish to make is a lot of new provisions that have been made were previously not covered. So the government is moving in the step of identifying some of the mischiefs which have been left out, where the government wants to arrest them, and they have incorporated a lot of things like organized crime, petty organized crime, terror has been defined. We have now an offense relating to endangering of unity, integrity and sovereignty of the country after repealing the sedition laws. What I find, madam, is that while we are making provision for dealing with offenses like this, the acts possibly at this point fall a little short of defining these terms and confining the meaning of these terms. Now, what has happened, madam, is when criminal laws use expressions that are very wide, the courts have held consistently, this is courts all over the world, including the Honorable Supreme Court in India, have taken a view that if the expression is not clearly defined, it may start affecting persons and citizens who are not originally intended to be captured within the provision of that mischief. This makes the law excessively broad. It may then become vague, and it may therefore be struck down. So we have had one provision of the IT Act being struck down on this theory. I fear that some of these provisions are going to be challenged in court, and therefore it may require, as I say, a further iteration. It may require at some point of time the Parliament to step back in and give a clear definition so that these expressions are confined to the area that they are intended for. This is again a suggestion so that we don't wait for many years to pass and for a court to eventually define how this term must be understood. Because the entire area of defining what the term will mean is essentially that of the Parliament, and I think that is a right that we need to exercise rather than leave it to the court to interpret because of a gap in legislation. I am not at this point, Madam, suggesting that there are gaps that cannot be filled. I am only saying that the law can be improved with further iterations after hearing the stakeholders. Madam, then I move on to the next point. Another reason why we support the bill is the idea to quicken the criminal justice process system, the courts and the manner in which an FIR will be lodged, a final report will be filed, the additional time that will be granted. All of this is good. The idea is noble, but it comes with a set of challenges. Madam, I would want to apprise the government that this is akin to the government wanting to have a very fast train, but the rails, the infrastructure is creaking. Madam, I appear in courts regularly when I am not here, and I have heard judges complain, including in national company law appellate tribunals, NCLTs, commercial courts and other regular courts, that the judges are working in most subhuman conditions because they have no assistants, they do not have a stenographer. Judges are writing 80 pages to 120 pages by hand because the judgment will have to be delivered under the CPC within 30 days after the matter is reserved. Now, we have made a provision that a judgment will need to be delivered within 45 days, but I have serious doubts whether the infrastructure would enable the coming into effect of this clear, noble intention of the government. Madam, I also have a suggestion here. The suggestion is, the central government will face a difficulty because the courts are a state domain. It is the states that will have to make provision for having adequate infrastructure. Center will not be able to sit on the state's head, and we sitting in the Council of States would not wish that the center should impose more than necessary. Now, if that is so, one of the ways the central government could consider ensuring that the intent that it has to have a first-rate criminal justice administration in the country is given effect to, without the states falling behind on providing infrastructure, possibly would be by providing for certain incentives like the Finance Commission does when states meet certain targets, be it in the power sector, be it in the educational sector, or solid waste management. Whichever states ensure that they are doing this, the Finance Commission is granting a higher share to the states. So if the legal reforms are also going to be included, specifically with reference to the criminal law justice infrastructure, then this act and the intent that it seeks to achieve can be easily accomplished. Otherwise, this might remain on paper. Like, Madam, we all know, the Representations of People's Act says that any election appeal in the High Court must be decided in 6 months. The law makes that provision, but we see that it rarely ever happens. Lucky are those legislators whose cases are decided before the person who won completes his term. Election petitions are now stretching for 4 years, 4.5 years. So while we may make a provision that a judgment must be delivered within 45 days, I am foreseeing some difficulties on the operational side because of the infrastructural deficiencies, so that may need to be attended to give complete effect to this law. Madam, then I have a suggestion to make with regard to the forensics. The provision of forensics that has been included, clause 176(3) of BNSS is a very important provision. The government has also taken a very practical view. The government notes that it may not be possible to operationalize this forensic study being conducted unless an adequate infrastructure is built up. So the provision says that it will come into effect from a date to be notified by the state government within 5 years. Now, in this 5 years, the forensic infrastructure may need to come in. But one lacuna I find, and this may have to be addressed separately, not through the criminal justice system, is that the forensic science and forensic study in India does not have any regulator like the medical institutions or any other institutions. So a regulatory standard may need to be set up, an accreditation which will recognize may have to be provided. So my suggestion, Madam, would be that the government make an appropriate provision for ensuring that the forensic framework is put into place. Sir, there is one other area that the government may have to consider, and the IT Ministry of the central government has doing a fantastic job in this. For the purpose of criminal investigation, we now enable the collection of biometric data by the investigating agency and by the court. Supreme Court says this is permissible. So there is no problem about the legality of the collection of some of this data. But the issue would be, where would this data be stored? How safe would this data be with the police and with the courts? How would the issues of privacy be covered? So these are some aspects that may need to be considered once these provisions kick in and they start operating from whatever date is notified by the state government. Sir, I then move on to certain aspects, because we are dealing with a set of three different laws. I'm just going in a seamless manner from one act to another in relation to the criminal justice machinery. Sir, the concept of fair trial and the right of an accused. So when I say accused, I am not speaking about a person who is convicted or is guilty. I am speaking, sir, of a person who is accused of a crime, and our law proceeds on the assumption that every accused will be deemed to be innocent until he is proven guilty. So a person facing a charge who is an accused starts off with this presumption in his favor. We have had a very famous saying by one Russian writer, Fyodor Dostoevsky, who said, the mark of the development of a civilization is not from the way it deals with the people who have achieved well in the society. It is in the way it deals with the criminals of the society. Sir, with these two philosophies in mind, I have three quick suggestions. Sir, on the aspect of bail, I find, sir, that a majority of the old provisions have been carried over. It is salutary because the Supreme Court has interpreted these provisions to say that bail is the rule, while jail is the exception. But what happened, sir, is because our justice system was not very good, we have noticed a tendency over a period of time that courts are hesitant to grant bails in any matter where it thinks the accusation is grave, because several of these matters were resulting in acquittals because of witnesses turning hostile or the evidence not being properly placed before the court. Sir, once the changes are made, once we bring in forensics, once we have a better administrative system, we should slowly now start moving towards the developed countries where the criminal justice system clearly adheres to the belief that a person will be released on bail once he provides adequate security and if he is not interfering with the criminal trial, and his punishment will start after he is convicted by the court, not by putting him in jail and not granting him bail even before he is found to be guilty. Because, sir, in many cases we see if person is in jail for 6 months or 1 year and eventually it is found that he is actually acquitted, then the civil liberty can never be brought back.
Please conclude, Niranjan Reddy.
Sir, I have...
you have 9 minutes, you have spoken more.
Very well, sir. I'll try to finish as quickly as I can. Sir, while the bail has been liberalized, sir, there's one area that the government may have to consider. Sir, clause 479 in subclause 2 says that the benefit that the government wants to give of half the term being already spent in jail and 1/3 if it is not punishable with life or death, the person is entitled to be granted bail. 479(3) says the above provision will not be applicable if the person is guilty of more than one offense or is involved in more than one case. Sir, even if a person is accused of only one offense, many times we see, sir, that in the FIR they list out 4 or 5 offenses. So even a first-time offender, in the first FIR registered against him, will have more than one offense mentioned against his name, which will deny him the benefit of the bail that is provided under 479(2) of the BNSS. Sir, the third of the issues relating to the rights of accused is in relation to handcuffs. While clause 43.3 specifies that it will be done only in some serious cases, the Supreme Court has clarified that this is ordinarily treated to be inhuman. It must not be resorted to except in exceptional cases. Sir, I would want the government to lay down clear guidelines. It is not that whoever is accused of that variety of offences need to be brought to the